what do we have today to discuss?
Yeah, Rahul, we've got a couple of topics. We have that the visa bulletin has U marked for India EB2 as well as unreserved EB5. We're going to talk about what that means. We're going to talk about noids, requests for evidence, denials, those a little bit of increase here depending on the situations and what folks should consider. We're talking about long delayed H4 EADs, a topic our firms knows a lot about. And we're going to talk about the impact of a speeding ticket on green cards. Rahul, we'll hit all four of those topics today.
So first, discussion on the unavailability and the visa bulletin of July. As we know that it just came out today, and it says that EB2 is U. What does that mean? That means that there are no longer green cards available for the people of Indian nationals under the EB2 category. Now, even if your priority date is 2006, 2007, 2008, whatever the date might be, they can't give the green card starting from July of 2025. July of 2026. Now, most probably, that means that it may not be available all the way until October of 2026. Now, September 30th of 2026. Starting from October, we may see the visa numbers available for the EB2. Most probably, the U will continue for the month of July, August, and September. In October, we would be able to see something in there. So for those people who have already filed applications, though, the EADs and advanced paroles will still be processed. They will not be denied. But for those people who are waiting for the green card to be approved, if it's not approved by the end of June, they will not adjudicate the application starting from July for the Indian nationals under the EB2 category.
Yeah, I mean, this is the only thing, Rahul, that's a little surprising about this, to be honest with you, is the timing. I think it's kind of strange because Department of State and all, they're supposed to only do this in a quarterly basis. So I think they're a little early, but, to be honest with you, outside of my weird concerns about that, it's good, right? It's good that they're using all of the visas in a year and we're not having wastage like we have in the past. And additionally, and I think a little less concerning to most of our listeners, is the EB5 unreserved is also unavailable. So this is the one that already was backlogged. It is not the set aside that's been current that most folks are pursuing. Those are still current for now. But, seeing usage is not a bad thing.
Yeah, so they have used up all the numbers, and most probably the 140,000, whatever excess that we've been there, they have used up all the numbers. So that's a good part. That the bad part is that the people have to wait for a long period of time. But things may change on October. We don't know how the things are going to move. How many of the unused family-based immigration green cards will pop up into the employment-based. We don't know. We'll see as things will turn out, and we will find out in this month of September. Now, on the notice RFEs and denials, there's a lot of raise in it, especially notice of intent to deny, notice of intent to revoke. Especially for those notice of intent to deny, RFEs, denials, the best thing I suggest all the people is to get the result of their visa status before the N-84 expires. I'm speaking of the main applicant. The dependent applicants, even if it's been delayed for a little bit, that's not going to be any problems. We don't see H4s or L2s denials at all, unless it's very rarely we see. It's only H1Bs and L1s. These are the things we get the denial. So if your H1B is expiring in September 30th of 2026, it's better that you get a result by September 30th of 2026, because if the denial comes in, you can always file one more extension. I mean, even though it's been denied, you can take the extension. You can transfer to a different company before the September 30th. But if you wait until October to get the adjudication done, and once you are in October, if the denial comes in, you'll have to leave the country. And of course, if you leave the country, we know the situation. If you want to come back, even though the $100,000 is not there, not there. Stephen keeps on changing that dialogue every week or every day. And some days he says that, oh, $100,000 fees is there. Then he says, no, it's not there. No, it's going to be there. It's not going to be there. So once you leave the country, if the $100,000 fees is there, then it's going to be applicable. Stephen, your advice on the NOIDs, RFEs, and denials, and one more time, the $100,000 expert.
Yeah, I don't know, man, with $100,000. You know, I did a video yesterday on this for our firm. I think the best way to describe it is it's kind of a zombie. It's dead. The rule is gone. The court said you have to vacate this rule, but the court didn't grant a stay, which requires the likelihood of success on the merits and harm and all that. But said, I'm going to grant an administrative stay so you can seek a stay at the First Circuit. That sounds weird to anybody who didn't go to law school, because it also sounds weird to me. All right, because I do this. It doesn't change the ruling. The judge didn't even go against it. It's just, hey, I'm going to let y'all government seek this at the First Circuit.
Stephen, you're going too technical. Is the $100,000 rule is applicable? Do I
as of today, yes, it is applicable. The judge stayed his decision, but
so what does that mean? If I file the H-1B right now for a consular processing, the USCIS can demand the $100,000 fees.
I think they can. I have a client, we're filing for them consular process because the individual is outside the U.S. and I just warned them, we're not paying the $100,000 right now. If they issue an RFE, we can circle back.
So now you're confused. 2 minutes ago, you said the $100,000 fees is there. Now you're telling you're not paying the $100,000.
I'm not paying it right now. I'll let them issue an RFE asking for it.
Okay. Well, it's very complex, guys, with the $100,000. But either way, if you want to avoid that, you're in United States, get the result before the I-94 expires.
Yeah, I think that's the big thing. Get your decision before the I-94, do premium if you have to, just because it saves you a lot of headache. And Rahul, if I can be honest, even if we take the $100,000 rule out, going for visa stamping is a pain right now. Across the U.S., but especially in Mission, India. I mean, we have appointments backlogged. We have insane administrative processing. So I try to, we want to get things done well before any sort of issue if we can.
Okay, sounds good. So any other suggestions before we go to your topic, Stephen?
Yeah, no, just again, just hit that as best you can. And then we'll talk about H4 EADs and those delays. So, we did a lot of litigation in the first Trump administration after the biometrics policy came in about H4 EAD delays. Some of them were getting a year long, if not longer. Fast forward to Trump 2.0. Joseph Edlow's back in a key role. Now he's the director of USCIS, and we're seeing these delays pop up again. They're no longer bundling. They are kind of bundling with the H4, but not the EAD. And then with the automatic extension gone, what good does that do, right? With work authorization. So we're back to bringing these lawsuits. I mean, kind of at the 3-month mark for people, individual cases is needed. I can tell you the delays aren't as bad yet. They're not a year long, but there's still some that are 6, 7, 8 months long. I mean, USCIS's standalone EADs are 13 and a half months. That's insane. So, we're bringing these cases so far, knock on wood, Rahul, they're effective. We're not seeing a lot of pushback from the government yet. I'm not saying this is the only way you can get a timely decision. It's the way I'm seeing work. But yeah, unfortunately, they're just back to delaying.
Tell me the process. Walk me the process, Stephen. You're telling me one thing, that if I file the H4 EAD and it's not, and I have to wait for 3 months before I go to the court litigation. Of course, I can try my congressman, ombudsman, senator, expedited request, which fails 99% of the time they fail. So when going to the court, you're telling me first is that I have to wait for 3 months to give a chance for the USCIS to adjudicate. If
Yeah,
the
I think this
H4EAD is still not approved, then I can come to you. And what's the process that is involved in the court? When I come to you, you file the court case and I get the approval within 1 week?
So no. Yeah, so we can sue to compel a decision. I want to be clear. If there's a reason to deny it, USCIS still can deny it. Guess what? I can count on like one hand the number of H4 EAD denials, right, that we've seen. It's all because issues with the H1. When we file the lawsuit, once we serve the government, through the mail with the lawsuit, they get 60 days to respond to a lawsuit. They can make a decision on the EAD, or they can fight the lawsuit. And it's something we caution our clients that can happen. We're not seeing it happen a lot yet, knock on wood, but we're ready for that. We know kind of how they're going to argue, so we're kind of ready for that if they do. But, within that 60 days, we generally see a decision. I can't guarantee that because, again, they can fight it. But for the most part, that's what we're seeing. And again, it's a tool individuals can use to fight back on these delays, right? To your point, Rahul, if you want to try your service request, talk to your congressman, great. We don't have to. We don't have to go through all those processes. But if you want to try it, I always tell people it's free. It's not going to hurt anything. I don't see it often work, but maybe it does.
So in general, though, I have to wait for 3 months and I come to you. And once I come to you, it takes approximately 60 days for the case to be adjudicated.
Yeah.
That's about it. Okay.
Yeah, generally that would be how it goes. I mean, like I said.
It's not going to be like I filed a lawsuit and next day I get the EAD approval in the mail. No, it doesn't happen that way.
Yeah, okay. No, I wish. I wish I was that magical, Rahul, but unfortunately.
Explain more. There are some questions that are coming. Are you still taking the adjustment of status delay cases, though? I'm not speaking of EB2 because by the time you file right now new cases, 60 days will be July and the priority date is not current for Indian nationals. But in general, if they are in EB3, if the date is current, how does it work out? I have filed a 485 application. It's been pending for more than 1 year. And the final action date is current and it keeps going back and forth, which everybody knows. So how does the lawsuit is going? I heard there are some hitbacks, fightings from the USCIS unlike before.
I've seen it too. The 485 Rahul's a little bit nuanced because as we all know from a couple weeks ago, it's discretionary. And so there's some arguments courts can't review it. I think that's a little bit of a flawed argument. I've heard anecdotally the government fighting on some of these cases, especially if you're, depending on the situation, but it's not going to hurt anything. This is the one thing I always tell my clients, Rahul, that I don't like seeing motions to dismiss from the government. That's how they fight these cases. They say, Judge, you should throw this case out. Yeah, those suck. We're going to oppose it. We then have to wait for a judge, and I can't control federal judges. I've tried. It doesn't go well for me. Your case doesn't get pulled out of line if the government fights it. So, at worst, it gets processed in the normal course of adjudication. At best, we're able to get things across the finish line, shake the trees loose, maybe get the order from the judge saying, no, make a decision. And it is definitely something, like I said, adjustment status, a little bit more nuance to it, but it works.
What do you mean nuance? That have you never filed before, or is that?
Oh no, we've done plenty of those. It's just an area that the government has more wiggle room to potentially fight. The one we see a lot of, and unfortunately popping up again, Rahul, is the adjustment of status interim benefits, the EAD, the advanced parole. Those work great too, kind of at the 3-month mark. Especially since, why do those take so long? When the question is, do you have a 485 pending? Okay. But yeah, reach out. We've got a pretty solid litigation team. I do want, a person on YouTube asked if we can sue to make them accept the filing date. No, unfortunately not. I wish. But no, we can't do that.
The last point with regards to speeding ticket, does it affect the green card? Now, if it's a speeding ticket, guys, if it doesn't involve any bodily injury to anybody, if it's just a regular speeding ticket, I'm not speaking of DUI, I'm speaking of regular speeding ticket. That should not cause any problem for your green card. That should, in your green card application, you don't have to mention it. You don't have to mention it in the DS-160 form when you apply for the visa stamping. That should not cause any problem in getting the H-1B, H-4 extension or for the citizenship. I'm speaking of regular speeding ticket, either your speed up, red light or something like that. That should not cause. If it involved in an arrest for you, that means they put a handcuffs and put you back in the car, definitely you need to contact an immigration lawyer to make sure that everything is there. I always tell people to keep a record of it. Let's say you got a speeding ticket. So what do you normally do? There are 2 or 3 different things people do. You pay the ticket. I want you to, some people go online and pay the ticket. Make sure that you have the evidence. And then after that, they will say the case is dismissed. You need to just get the documentation you paid the ticket for it. And then you keep it with you though. Send an email to your cousin, just in case if it gets deleted somewhere, you can always recollect it from your cousin. If the other thing is people go challenging the court. I'm fine with that too. As long as you challenge in the court and you get it dismissed or you pay the fine, either way, it doesn't matter. It won't negatively affect your application. The third way people do is that they take some classes and then they get it dismissed. All 3 are good. What is bad is you get a traffic ticket and you say, I don't care about it. Not good, because then you're going to get an arrest warrant. That's going to cause a problem for you. As long as you take care of it, either you pay it, you challenge it, or you take some courses to get it dismissed. All 3 are good, but not neglecting is definitely is not an option.
Yeah, don't get the bench warrant. There are a ton. I don't know. I've had a couple of speeding tickets here in Texas. I get all sorts of mail from attorneys. I've fought a couple. Take a look. It's usually worth it, but don't just ignore it. Don't just ignore a speeding ticket. That's when it gets bad.
The good part in Texas is that when we get a speeding ticket, even if I want to hide it from my wife, I get the love letters from the lawyers. Hey, do you want to defend it?
It's funny. I got pulled over one time studying for the bar exam, and I was like, dude, I just can't deal with it. He said, well, you can go fight it. If I don't show up, it'll get dismissed. And I asked him, I said, well, do you usually show up? And he said, no, I don't show up. So there I went to court and it got dismissed. So,
but you went to the court.
I did. I went to the court, went for docket call and sat there, spent a few hours in the courthouse, and it worked out. So again, I think the big thing, Rahul, is, run-of-the-mill speeding tickets, it happens. I would say you're, assimilating pretty well to American culture, getting a speeding ticket. And just don't ignore it, because if you get that bench warrant and you get arrested, that's when it becomes a problem.